Hi, good morning, everyone, and thank you for tuning in to Higher Levels High Notes today. We are going to be joined with Tasha and Phil and talking about the COVID-19 best practices and phase reopening. So a few things before we get started. The call will last about an hour, and you are all set up in listen-only mode. So our panelists, they will discuss the topic, and if you have questions towards the end of the presentation, we would be happy to answer those for you. You can type those in the go-to webinar question box. At the end of the presentation, we will leave time for that. So let's go ahead and get started. I'm going to introduce our speakers for today. Thank you, Phil, and thank you, Tasha, for joining us. So Phil Graham has over 27 years of experience with litigation. He is a member of the firm Sandberg Phoenix Business Litigation and Products Liability Group. Phil is an experienced insurance coverage and bad faith lawyer representing commercial insurers in complex coverage disputes involving various lines of commercial insurance. He is experienced in providing coverage options and litigating coverage in bad faith cases. Phil is also experienced in defending and counseling employers in employment discrimination and wrongful termination litigation, including EEOC and parallel state matters. Tasha Childs joined Sandberg Phoenix as an associate in 2019. She was part of the firm's 2017 and 2018 summer associate programs. Tasha enjoys spending quality time with family, especially her daughter, dancing and traveling. Tasha is a member of the Bar Association of Metropolitan St. Louis with a JD from Southern Illinois University School of Law, Criminal Justice from Illinois State University. Phil and Tasha, I turn it over to both of you, and thank you for joining us this morning.
Thank you so much, Erin. We are so happy to be here with you all today. Thank you for having us. We hope that this presentation will be both beneficial and useful to all of you, and we look forward to answering your questions. So without further ado, I will go ahead and get started. This presentation is titled COVID-19 Best Practices for Phased Reopening. We wanted to start off this morning with highlighting some expectations from the U.S. Chamber of Commerce. As some of you may have already experienced, reopening will be much more complex than implementing the shelter orders. There will be no single best solution, and as employers and business owners, you will need to incorporate multiple strategies to accomplish successful reopening. Solutions that work for one employer may not work for another. So you just have to identify which solution works best for you and be flexible, as questions and answers will likely change daily. Even as we were preparing this presentation, there was a new law implemented on June 5th that Phil will discuss a little bit later, but we had to adjust. So as employers and business owners, you must be flexible and just try to adapt as best as you can. You should anticipate that your return to work policies will be a state and local led effort. What one state does may be different from what another state is doing. So just anticipate some direction and guidance from your local government. You should also expect financial support from the government to achieve successful implementation. This may be in the form of funding or maybe in the provision of medical supplies. But one way or the other, you should expect the government to assist. Now we want to discuss some of our suggestions of best practices to permit safe and successful return to work. First best practice is the use of thermal screening protocols. These are the least invasive measure and they are the easiest to implement. I had to attend a dental appointment last week and they quickly took my temperature. It took about 10 seconds before I could enter the building. And once I was cleared with a clear temperature, I was able to proceed in to get my dental cleaning. You also may want to consider the use of COVID-19 testing by employers or third parties. This will probably be a healthcare professional that should do these COVID-19 tests. For example, you can require your employees to present you with a clean COVID-19 test that they are negative for COVID-19 prior to returning to work. But that should be done by a healthcare professional. You also want to require personal protective equipment, and that may include some training as well, as far as when you expect your employees to wear the PPE equipment, or where in the facility you expect them to wear it. We are required in our building to wear masks and gloves when we are in all of the common spaces. The only place we do not have to wear them is in our personal offices. So, for example, some PPE equipment will include masks, gloves, or maybe even gowns, depending on your situation. You also want to adhere to social distancing, regular hand washing, and disinfecting services. We received a notification from our firm that we will see an increase in our cleaning personnel. So that's one way that our job is maintaining our safety and in notifying us of the measures that they are implementing. You should also consider a staggered work schedule to not only allow for social spacing, but to accommodate some of your employees who may have school-age children. And now that the summer programs are not opening, or some are, but some parents may feel a little weary about sending their children to those summer camps, you might want to just allow for staggered work schedules for your employees. Our firm, for example, has given us 3 options. Our option A attorneys will be working Mondays and Wednesdays in the office. Our option B attorneys will be working Tuesdays and Thursdays. And our option C attorneys will be working remotely and coming into the office only on Fridays as needed. That's just one example of something that you could do if that is a solution for you. And you always want to require employees to self-quarantine for at least 14 days prior to returning to work if they have recently traveled. Our firm requires us to report to a designated HR personnel with whom we communicate where we've traveled to, our mode of travel, and she will let us know if we are required to quarantine or not. So you definitely want to be asking your employees about that information before they return. We also wanted to provide you with the CDC's guiding principles on the next few slides. We don't have all of them listed here, but we've highlighted some of them. First, you want to encourage your employees who have COVID-19 symptoms or who have had contact with someone with COVID-19 to, of course, self-quarantine and seek testing. Should encourage your employees to cover their coughs and sneezes with a tissue or their inner elbow, and to immediately wash their hands. This information should be communicated verbally and in a written format. You want to ensure that you have adequate supplies to support these healthy hygiene behaviors, including sufficient amount of soap and hand sanitizer, paper towels, tissue, disinfectant wipes, cloth face coverings as feasible, and no-touch foot pedal trash cans. One thing that our firm has done, which I highly suggest, is identifying a workplace coordinator, probably someone in HR who can handle the COVID-19 questions, concerns, updates, and information to your staff. You want to post signs in highly visible locations to include entrances and your restrooms that promote the protective measures. And the CDC has a free print and digital resource on the Communications Resources main page as an example that you can use if you would like. As you can see, there's one example here on this slide of a sign that you can post to encourage and promote protective measures. You want to develop a schedule for increased routine cleaning and disinfection. And if you have employees who are disposing of trash, they should use gloves at all times if they weren't prior to COVID-19, and immediately wash their hands. As I stated before, in our firm, we have to wear gloves all throughout the building, except for in our personal offices. When possible, you want to discourage sharing of items that are difficult to clean, sanitize, or disinfect. That's very highly important to reduce exposure, and use touchless payment options if that is available. You want to ensure that your ventilation systems operate properly and increase circulation of outdoor air by opening windows and doors. Of course, you don't want to do this if this poses an additional safety or health risk, for example, the risk of falling. So just think about those considerations before doing that. And you want to close any shared spaces, such as break rooms where possible. Otherwise, you do staggered use and provide for cleaning and disinfecting between those uses. We don't have break rooms on every floor in our firm, but we have a common area where we can store our lunches, warm up our lunches, and get drinks and get coffee and things like that. But our firm is only allowing one person in those areas at a time, just to promote social distancing and to make sure that we are remaining safe. And for your employees who have higher risk, you might want to modify their duties as well as their shifts. For example, if they can manage inventory rather than working the cashier, for instance, you'd want to promote that. Or if they can continue working from home, that is something you should definitely consider. Now this slide was a little blurry, but you can find this flyer on the CDC's website, and it walks you through whether you are safe to open or not, according to the CDC. On the first column, if you're able to successfully answer all of those questions in the affirmative, then you can proceed to the next column, and so on and so forth until you reach the final column where the CDC says you're safe to open and monitor. So you might want to take a look at that at cdc.gov/coronavirus, just to make sure you are ready to open.
Great, thank you, Tasha. Good morning, everyone. And I'm Phil Graham. I am head of Sandberg Phoenix's labor and employment team, and Tasha is a very valued member of our team, and in fact, prepared the materials that you're looking at today. So I want to thank her for that. And I'm next going to talk about a couple of things. One will be first kind of a reminder on job restoration rights, and then we're going to talk about just some highlights of potential legal liabilities, issues to think about as you reopen, or that might cause you to think of other issues that are specific to your business that you ought to consider as we move through this time. So job restoration rights. This refers again to any employees you may have had out on the Emergency FEMLA Expansion Act. The law requires that an employer restore those employees to their prior positions or a substantially equivalent one upon the expiration of their need for leave, unless the employer has fewer than 25 employees and the employee's position no longer exists due to operational changes that were occurred because of the COVID-19 pandemic and crisis. If there are no equivalents, if the same position or an equivalent is not available, the employer does have an obligation to continue to monitor and contact the employee if an equivalent position becomes available in the next year. All right, so next we'll talk about some potential legal liabilities. These may not apply to every business, and of course, it's not an exhaustive list. It's just some ideas and some things that we think you ought to consider and may be helpful for you. So using objective measures wherever possible. This is always important to use objective measures anytime in your employment practices where possible, since that tends to mitigate your risk of being accused of discrimination. So for example, you can provide a form to employees prior to their returning to work where they can indicate to you if they are immunocompromised, for example, or if they live with someone who is, but without requiring disclosure of the specific reason why they're immunocompromised. That way you're able to offer protection to that employee and to others and to understand what your risks are as an employer. Another consideration may be to only allow so many employees to enter the work site per shift if that works for your business. I do know that some manufacturing clients of ours have modified their lines and their processes during this time to modify, to add shifts, to split shifts, so that they're able to better social distance and better mitigate the risk. So those are some considerations you might think about. Other potential legal liabilities. Health privacy. This is a big one. We don't want to be requiring disclosure of underlying health issues by employees. and we certainly don't want to be disclosing any health information that we do obtain from our employees, to their coworkers or others who aren't in a position where that's something that they're required to know from a business management standpoint. Employers can disclose that an employee of your company has tested positive for COVID-19, but of course you can't disclose the identity of that person or persons to other employees. This is easier in larger organizations to manage because it's less likely that people will figure out who the employee is. So this requires a little common sense too, depending upon the size of your organization and how you handle that information. All right. Independent contractors, always a source of potential legal liability for employers. Of course, this is because you can become liable for your independent contractors through an agency theory if you, as the employer, exert control over their means of production. So in other words, if you control how they're performing their job, provide them with all of their tools, tell them how the work is to be performed, then you're getting to a situation where it's more likely they're going to be viewed as an employee rather than as an independent contractor. And this is important during this time because you may be issuing personal protective equipment to your employees. You may be providing it to others as well. Just be aware that the more tools and the more means of production you're providing to independent contractors, the closer you're getting to them being an employee. Other employment practices to consider, you may want to implement guidelines to avoid liability from employees who refuse to submit to thermal testing or who view returning to work as a danger and refuse to return. I do think that latter comment is going to be a big issue. There are going to be employees who will say they don't feel safe yet to return to work, taking those folks at their word, because I think the vast majority of people who tell you that are going to be sincere and really believe that. People have been frightened by all of this, so it is going to be difficult for some people, more so than others. One of the things we've been counseling our employer clients about a lot is to just be aware of the spectrum of people and their understanding and handling of risk. In my case, I can even see it within our family. Some are more risk averse and more worried about this than others. And so certainly in the employment context, it's something to be aware of and be as sensitive to as possible. Understanding obviously that the business has a need to operate and key employees need to be able to come to work and to perform those duties. Okay. Other potential legal liabilities. There are exposure liabilities that can be arising from this. There are product liability concerns, medical liability claims in certain cases for certain employers. If an employer has not provided sufficient measures to protect employees and customers, there are a lot of the retail establishments are mitigating risk to both their employees and the customers by employing the plexiglass shields and screens, for example, that you might see at Walgreens or CVS in your local grocery store. Those are all things to consider that, whether they'll work for your business depending on what you do or not. But you might think and sit down and really consider what are some things I can do to help limit exposure, to distance people, and just to really mitigate the risk. Because if you're doing those things, you really can, I think, based on the guidance we've seen and read, you really can mitigate a lot of the risk. Of course, for publicly traded companies, there's always the risk of securities litigation and claims of misleading investors. And this is, of course, there are always going to be opportunists that are going to look for those opportunities. So we've got to be extraordinarily careful how we handle information and how we make representations to investors and others. Other things to be aware of: Telephone Consumer Protection Act, TCPA. Be cautious about using phones and text to provide mass notifications and automated text to customers and others. False Claims Act. This really goes, again, more to the payroll protection program and the loans that have been made available by the banks to the Small Business Administration. We would anticipate that there's going to be a fair amount of claims made that there's fraudulent use of funds. So, again, be aware that that's out there. All right, other anticipated employer liability protection issues. Not seeing a lot of it yet, but we do expect that there will be safe harbor clauses and executive orders and perhaps new legislation tailored specifically to COVID-19. These slides were prepared a while back. Thought we might have seen more of that by now, but we may still yet in the coming days and months. It's important to adhere to governmental guidance concerning recommended protocols to protect your employees and customers, and use good faith and reasonable efforts, to reduce your liability exposure. Those things are important, sort of regardless of your own personal view of the risk level or your own personal, feelings about it. Again, because others are more sensitive to it, and you are bringing people into your business, particularly your customers and others that you don't know as well, and you may not understand what their specific exposure risks from a health perspective and what their feelings are about it. And so the more you do that's reasonable and in good faith, the better you're positioning yourself to minimize your liability. And it's not in the slides, but before I turn this back over to Tasha for the next section, I did want to mention the Illinois Biometric Information Protection Act. This is a big source of potential liability for employers and businesses generally, and it is a developing area of litigation. It has become much more, this law, BIPA is what it's called, BIPA, has been on the books in Illinois since I think 2007, 2008, but the litigation has really ramped up recently because of a decision from the Illinois Supreme Court. And now the Seventh Circuit Federal Court has issued a decision which also makes it easier for claimants to bring cases in federal court. But essentially what this law requires, and you should get guidance from your legal counsel on this, but essentially it requires a written consent and disclosure notice signed by your employees or others before you obtain biometric information from them. And I would suggest to you that taking a temperature and obtaining health information may fall under BIPA. And so it will be worth looking at that and protecting yourself from that liability, which can be fairly easily accomplished with a written waiver and consent. But I wanted to point that out because I do think that is an area that's a real pitfall and an area that you can really open yourself up on. So with that, I will turn it back over to Tasha, I believe.
Thanks, Phil. So next, we wanted to provide you with some guidance from the Equal Employment Opportunity Commission. The EEOC will still enforce workplace anti-discrimination laws, including the Americans with Disabilities Act, the Rehabilitation Act, Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, and the Genetic Information Non-Discrimination Act. While these laws do continue to apply during the pandemic, they do not prevent you from following the guidelines and the suggestions made by the CDC and other public health authorities about the steps you should take regarding COVID-19. But if you are following those guidelines, they're applied in an objective fashion. So as long as you're applying them in a non-discriminatory way, you should be safe from any issues with the EEOC. The Americans with Disabilities Act also permits employers to make disability-related inquiries and to conduct medical exams if they are job-related and consistent with your business necessity. Now, these inquiries and the reliable exams will meet this standard if they are necessary to exclude an employee with a medical condition that will pose a direct threat to health or safety. As an employer, of course, you may ask questions about potential COVID-19 symptoms and take temperatures. And while some people with COVID-19 do not display symptoms or do not have a fever, we found that generally this is one of the best measures to ensure the safety of your employees and customers, and to kind of weed out those who should not be entering your building. The EEOC recommends that you continue to review guidance from the U.S. Food and Drug Administration, the CDC, other public health authorities. And you should also check for updates concerning safe reopening and accurate testing. As we stated in the beginning, these measures are going to change daily, so you want to do your best to remain up to date. This is also an important point, is that you want to be sure to maintain all information about employee illnesses as a confidential medical record and keep it separate, my apologies, from the employee's personal file. Oftentimes, as employment law litigators, we may see medical files within the personnel files that we receive on cases that we take, and that is definitely an EEOC violation. So you want to have that personnel file kept separate from the medical file. For example, if you're asking questions about COVID-19 symptoms, taking temperatures, all of those kinds of things, any underlying issues that you may be aware of, underlying illnesses that you may be aware of, all of that needs to be kept separate and confidential. The Americans with Disabilities Act also permits employers to require a doctor's note certifying fitness for duty. During this time, doctors are less likely to want to do that. They may subject themselves to more liability if they certify that a person is fit for duty. So you'll more likely want to just rely on your local clinics to provide you with a form filled out or an email certifying that the employee does not currently have COVID-19. And employers may disclose the name of an employee who does test positive for COVID-19 only to public health agencies. As Phil indicated earlier, that should not be shared with other employees. And also, this is another thing you should consider, is that your employees who had prior accommodations, they may need an additional or altered accommodation, absent any significant difficulty or expense on your part. You should provide those altered or additional accommodations. As an employer, you can discuss whether this is the same or a different disability that is the new basis, and you can ask why an additional or altered accommodation is needed. And again, if you can provide it without much difficulty or without much expense, you should do so that you do not violate the ADA. An individual who has COVID-19 or symptoms, of course, should not be in the workplace. So according to the CDC, you may delay their return and start date of these employees and applicants. You can also withdraw a job offer if an individual has indicated they have COVID-19 or symptoms associated with it. You also should consider low-cost solutions. At the beginning, we talked about identifying the best solution for your particular situation. You also want to try to save money in the process and reduce your funds that you are putting out to cover these protective measures. Some of these Phil kind of discussed earlier, but again, we just want to highlight them. Low-cost solutions include designating one-way aisles, using plexiglass, tables, tape marks, or other barriers, just to ensure minimum distances when feasible. As we begin to reopen, it will be difficult for some and maybe more difficult for others. So businesses that are dependent on high density gatherings and travel, such as restaurants or movie theaters, will have a bit more difficulty than other businesses, but you just want to follow the guidelines that are being set forth by your local government as far as what your capacity levels are limited to and when you can move forward with increasing those densities. Employers who have employees who experience hardships that delay their return to work may also have some difficulty opening. For example, if your employees fall into a vulnerable category, if they lack childcare, there may be some difficulty with you reopening. But again, you want to just be flexible, allow staggered work times, just do the best that you can to get money coming into your business, but to keep everyone safe at the same time. And if at all possible, you should definitely strive to continue operating remotely. Back to you, Phil.
Thanks, Tasha. I wanted to kind of reiterate a couple of the things that Tasha talked about that are really important and I think worth kind of emphasizing. And one of those was keeping employee medical records and information separate from their general personnel file. That really is important, and as Tasha indicated, it's not been altogether unusual for me over the years when looking at, when we're defending an employment case, the first thing we usually ask for is the personnel files of the involved individuals. And, it's not altogether unusual, particularly for long-time employees, sometimes a medical record to somehow creep into the employment file, whether it be from a work-related injury or some other reason. But be very careful with that, and really, as Tasha indicated, make sure you're creating a separate medical records file to keep those in that is kept separate from the personnel file. Back in the old days of paper files, what we would recommend is keeping the medical records in a separate locked file cabinet. And so, you can do the same thing electronically, and probably easier, but you may want to have separate access to those areas electronically and limited to those that only really need it. Because, if you are investigated for a charge of discrimination, you'll also be producing documents and personnel files. And believe me, if the government sees medical records in the personnel files, then you're off onto a whole separate issue aside from what you came there to begin with. So just want to reiterate that. And then I also mentioned reviewing your employees who are receiving reasonable accommodations under the ADA or similar state laws. That's important too during this time. People have been working remotely for 2 to 3 months now, depending on where you're at. Their workstations at home may be different than they were in the office or whatever their work is. So now is a good time, if you haven't done it already, to review with those folks, the accommodations they've been provided. Do they need anything else now at home? Are they getting along okay? Is there anything different they're going to need when they come back to the office? This is a really good time to do that and fulfill your obligations to engage in what the cases in the EEOC calls the interactive process, because we have a duty as employers to interact with our employees on accommodations, what accommodations can be reasonably provided, just as the employee has a duty to engage with the employer on that. So, this is a lot of this is an opportunity, I think, and this is one of those opportunities to go out there and make sure that you're providing what's going to be necessary to fulfill not only your legal obligation, but also to make sure that those employees are being as protected as possible for you. So with that, I will move on to our final section, which we're going to talk a little bit about phased reopening and the CARES Act. Way back on April 24th, 2020, which seems like it was about 5 years ago, but hasn't even been 2 months yet, Congress passed the Payroll Protection Program and Healthcare Enhancement Act, which was at the time, I think, a nearly $500 billion stimulus bill, and included a little over $300 billion to replenish the SBA program, $60 billion for a separate economic injury disaster loan program, $75 billion for hospitals, and $25 billion for virus testing. And then there were, of course, the Payroll Protection Program loans. If you obtained one of those loans, you will, of course, be familiar with your loan documents. The terms of your loan were probably for 24 months. The interest rate was probably around 1%. And your first payment should not have been due until 6 months after your first loan fund disbursement. I'll leave most of the accounting treatment to these loans to the CPAs, but obviously those are recorded as cash on your balance sheet, and the current portion of the debt is recorded as a current liability, with the portion of the debt extending beyond 1 year recorded as a non-current liability. Interest is accruing on the outstanding loan balances, beginning with the date of the loan issuance. Not all lenders will have the same computation or calculation. So again, you want to review your lender's terms and loan documents to really understand how your interest is being accrued. Now, what everyone is most interested in is, of course, forgiveness of these loans. And as a reminder, PPP borrowers must apply for forgiveness directly with their lender. Lenders have 60 days to approve these requests, and the SBA will reimburse within 30 days from the issuance of forgiveness. At least that's the idea. All right. Now, these next two slides, actually, I'm going to kind of skip over because of what was enacted last Friday. And I added some new material at the end to talk about PPP loans and forgiveness because this has now shifted a little bit and may be a little different than what it was from the beginning. So let me get over here to the new slides. Initially, we were looking at eligibility period for forgiveness ending 8 weeks after the lender distributed the loan proceeds. We were looking at a 25% limit on the use of loan proceeds from non-payroll expenses, and we were having to look at issues regarding average full-time equivalent employees by June 30th, 2020, with respect to impacts on forgiveness. But last Friday, the President signed into law the Payroll Protection Program Flexibility Act of 2020, the PPPFA. As I said, this was signed on June 5, 2020. It substantially modifies certain provisions of the CARES Act relating to forgiveness of payroll protection program loans. It's significant since many PPP borrowers are coming up on the end of the previously determined 8-week loan forgiveness period. So this is something to get on top of with your lender and your legal counsel if necessary. So we'll kind of go over some of the key provisions of the Flexibility Act, which could impact forgiveness of these loans. One is an extended maturity of the loans. This changes and extends the 2-year loan repayment term to 5 years for new loans. Employers with existing PPP loans should discuss modifying their repayment dates with their lender if they're expecting a portion of the loan to not be forgiven. And really, at this point, it's a little bit of anybody's guess as to how forgiveness is going to work. But if you believe at least any substantial portion of your loan is going to be forgiven, it may be worth going to your lender now and seeing if you can extend the terms, if that's beneficial for you. There's an extension of the date to use proceeds from June 30, 2020, now all the way to December 31, 2020. However, for forgiveness, the funds will need to be used within the specified covered period. And the time period has been extended for forgiveness. The covered period in which PPP loan proceeds must be used for certain purposes to be eligible for forgiveness have been increased from 8 weeks from origination of the loan to the earlier of 24 weeks from origination or December 31, 2020. So employers who already have their PPP loan may elect to keep their 8-week covered period. All right. Some other key provisions to consider are added employee availability or inability to return to same level of business. and the forgiveness considerations that go along with this. Loan forgiveness can now be determined without regard to the reduction in full-time equivalent employees if the employer, in good faith, is able to document an inability to rehire individuals who were employees on February 15, 2020, and show an inability to hire similarly qualified employees for unfilled positions on or before December 31, 2020. Or if the employer, in good faith, is able to document the inability to return to the same level of business activity as business was at or before February 15, 2020, due to compliance with requirements or guidance issued by Health and Human Services, CDC, OSHA, or the like, during the period beginning March 1, 2020 and ending December 31, 2020. Again, related to the maintenance for sanitation, social distancing, or any other worker or customer service or safety requirements that we've been talking about here today related to COVID-19. All right, another key provision in this act, the payroll forgiveness limit has been reduced from 75% to 60%. So in order to have loan proceeds forgiven, at least 60% of the loan proceeds now, rather than 75% at the outset, must be used for payroll costs and expenses. Furthermore, 40% of the proceeds may be used for other uses that are subject to forgiveness. This would include payment of interest on any covered mortgage obligation, covered rent obligations, or covered utility payments and the like. The payroll tax deferral benefits. Employers may now take advantage of the payroll tax deferral, notwithstanding forgiveness of PPP loan indebtedness. This is a significant development. And PPP loan borrowers who obtain loan forgiveness may also benefit from the payroll tax deferral without limitation. All right, so some of the final recommendations that both our employment and our banking team have been giving to our clients with regard to handling PPP loans are, really just sound business practice to begin with, but really doubly important with respect to these loans and your ability to obtain forgiveness is, one is maintain accurate and really complete documentation of your use of the loan proceeds. If it's possible, using a separate bank account for these loan funds and the disbursement of them may help you in tracking that and documenting that. And it's important to remember that these are loans, they are not grants, and they are controlled by the terms and conditions of the loan documents from the loan. So that any funds that are remaining from the loan that are not forgiven, they will become the employer's debt obligation. I've had a couple of nonprofit clients in particular who earlier on this obtained PPP loans, and we're talking in terms of talking in terms of it being a grant. We really had to sit down and say, no, there's forgiveness available. I don't know exactly how that's going to work, but it is a loan, and so it's important to remember that. All right, I think that brings us to the end of our prepared remarks. Again, Tasha and I both thank you for allowing us to present to you today. It's really obviously a challenging time and something that none of us have ever seen before. If we're lucky, hopefully we'll never see it again. But it's obviously stressing businesses and their employees and customers. And as Tasha noted, really one of the key things to note as we return to work and return to business is flexibility. To the extent you can be flexible, particularly as this event unwinds and continues, and in reality, at least through the end of this year, we're going to be dealing with the impacts of this. And so to the extent you can be flexible in your employment practices and with your employees, I think it should be a real benefit to you and will help you and minimizing the potential for liability. So with that, I'll conclude, and then we're available for any questions and answers here. And again, we thank you.
All right, great. Thank you very much. So now's the time. If you all have any questions, feel free to type those into your question box on the GoToWebinar panel. We would be happy to get those answered for you. Also, if you are interested in receiving information like this in the future, or signing up for higher levels monthly high notes presentation similar to today, you can email hello@higherlevel.com, and we can make sure that you're added to the list for future events. We do these on a monthly basis and would be happy to have you attend in the future. I know some people were asking, our webinar program does provide you with SHRM continuing education credits if you do attend the event. So we will be sending those credits out to you later on this afternoon as a follow-up email, and also with the recording presentation. And I do not see any questions, Phil and Tasha. So I appreciate you covering the information thoroughly for us this morning and spending time with us.
Thank you, Erin.
No
All
problem.
Thank you again, and everyone have a good rest of your day.
right, thank you.
Take care.